Good morning.
Welcome, and you may begin whenever you're ready.
Thank you. Good morning to all of you, and I very much appreciate this opportunity to talk with you today. I'd also like to say how much I appreciate the other applicants being a part of this important process. Thank you to them as well. My name is David May. I'm 51 years old. My wife Paula and I have been married for 25 years now. We have two children, Gretchen and Matt, and we're very proud of them. Paula and I are Iowans by choice. We both grew up in Kirksville, Missouri, which is about 30 miles south of the Iowa border. But we've now lived in Iowa for more than half of our lives, and we've been out in Polk City for about 19 years now. So Iowa is our home, and it's been my distinct privilege to serve the people of Iowa as a district court judge and now on the Court of Appeals, and I very much hope to also serve on the Supreme Court. I just want to make 3 points, 3 criteria that I think are worth thinking about when choosing Supreme Court justices and that I believe are supportive of my candidacy. Background, judicial decision-making in general, and then decision-making in an appellate situation. First of all, I think that humbly I would suggest my background is both deep and wide in the sense that I've worked for a small firm, I've worked for a rather larger firm, I've represented a variety of individuals, I've represented a prisoner, I've represented farmers, I've represented injured plaintiffs, I've represented very small businesses, medium-sized businesses, and some of the largest businesses. I then had the opportunity, as I mentioned, to be a district court judge for 3 years, and that gave me not only the practical working knowledge and experience of being a judge, but also the opportunity to do deep dives into other subject matters, family law and criminal law, post-conviction relief, administrative law. And now I serve on the Court of Appeals, and where I've been for the last 3 years, and that again is touching on all those areas of the law that I just mentioned and adds on juvenile law as well, and serving not only a small area of the state, but 99 counties. And I've had the opportunity to author over 300 opinions. So I think that if you consider those experiences together, I think that gives me a solid background for stepping to the next level with the Supreme Court. I'd like to next mention just the role of the judge. How do we think about the role of the judge, or any court really? And for me, it's relatively simple. We need, in the sense that we need to apply the law faithfully to resolve the specific disputes before us. And that is as opposed to the view of going out and finding issues that are outside of the case to decide, or creating law strictly out of our personal preferences when the law as it's written requires something else. And it's one thing to talk about these issues, it's another thing to have a record. And I think that if you take a look at my record as a Court of Appeals judge, it's easily accessible. What you'd find is someone who is out there trying day in and day out to do just that, apply the law to the issues in the case and come to the right result. And that's what you want from a judge, or at any level. The last thing I want to talk about is appellate judging, because it is different than being a district court judge. When you're a district court judge, if you have a summary judgment motion in front of you, you type up your ruling, you hit send, you don't have to talk to anybody else before you do that, it just goes out. It's different on the appellate court, right? We have to work together. On the Court of Appeals, we work in 3-judge panels. And what you need, in my experience and opinion, is a mix of collegiality and independence. On one hand, being a good colleague is about supporting your fellow judges, sharing your views with them, helping them in their process to understand cases, talking through issues, and in many cases, it means that we're able to come together and come up with a unanimous result. At the same time, it's not always kumbaya. There is disagreement, and Iowans are entitled to 7 independent minds on the Iowa Supreme Court. They don't have to settle for just folks who are going to follow others. And so you've got to have that independence of mind, that willingness to form your own opinion. Certainly you're going to, again, discuss it with your colleagues, see where there's common ground, but sometimes you just have to write separately. And that's exactly what we do on the Court of Appeals. A case is before us, we'll talk it over, maybe we'll reach a unanimous view, maybe we'll have to write separately. But then we move on to the next case without letting personal hurt feelings or toxicity or any of those things come into it, because we're focused on the mission. It's not about Dave May and his ego. It's about the mission of the courts to get the right answer in cases. And that's the view that I believe is prevalent in our courts, and that's the view that I would bring as a Supreme Court justice. With that, I would welcome any questions.
Mr. Hoyting?
Thank you. You touched on this a little bit in your statement, but I'm going to give you an opportunity to elaborate more on it. So this is my, I think, 7th time coming through and doing judicial vacancies. And one of the things that is common is you do hear from judges, both applying and currently sitting on, how important it is for these courts to have people with judicial experience. Mostly from the district court perspective, but you are the one candidate that has experience on the Court of Appeals, and the Supreme Court reviews decisions of the Court of Appeals. Can you talk a little bit or elaborate a little bit on the value of that experience? Or elaborate more, because you did touch on it.
Sure. Well, it's like I always say, you know, we've all been through McDonald's many times through the drive-through, but until you're behind the counter, you don't really know what goes on. and there simply is a different perspective when you've actually done a job. If you're going to be the judges of judges, it helps to have been a judge, to know what is possible, what is outside their capacity, what to expect from them. And that goes to not only in the deciding of cases, but also on the administrative side, because the Supreme Court is administering a 1,700-person branch with judges all across the state, with other staff all across the state, and somebody who has actually worked on the 3rd floor, that's where the Court of Appeals is, would have a much better view, I think, of what does the 3rd floor really need? Do they need another staff attorney? Do they need less? Do they, you know, what are the assets that they need? What are the ways that we can help them continue to do their job? And so I think that's extremely valuable. And then, of course, the district court experience, just knowing what it really is like to have to decide cases and what district court judges need, I think that's valuable as well.
Thank you.
Thank you.
Ms. O'Brien?
Thank you. Thank you, Judge May, for your application. In our meeting, you suggested that the biggest challenge the Supreme Court faces right now is the perceived politicization of the court in its rulings. I hope I'm not misquoting you, but with that, I think, as a recognized challenge that the Supreme Court is facing, could you address the need for the court to create law and avoid exercising personal preferences, including politics and religion?
Well, we certainly did discuss several challenges facing the Supreme Court, and one of them is undoubtedly a perception of political bias in the process. There's no two ways about that. And that applies both to the state courts and to the federal courts right now. Anybody who's watching the news knows that. To me, the best way to avoid the perception that judges are making up the rules as they go along is, particularly when we talk about democratically produced texts like statutes, to carefully follow those texts and to not substitute our own viewpoints for those texts. And so I think that's a method, and I know that other candidates have discussed that as well. It's not to say, and I might add just as a general statement, that I really enjoy talking about the law with everybody today, but as a sitting judge, I'm making no promises or commitments about how I'll decide any future case. But I think my record bears out that I have continued, over the 300 cases that I've written, have continually followed that approach. And I think that's one way in which we can address that issue.
Thank you.
Mr. Graber.
So you're looking to switch jobs, and we appreciate you being here, and appreciated my time together with you. What's one or two things that you are looking forward to leaving behind in the Court of Appeals and moving on to the Supreme Court?
The Court of Appeals is an amazingly great job, and this may be against my interest, but I'll just say that if it doesn't work out, I'm going to be happy there. And I hope that every applicant or every potential applicant who is watching right now hears me say that. And if there happens to be an opening in the future, that they consider diving in, because we get to review so many different kind of interesting cases in a fantastic environment. One thing I do look forward to is I think issues of first impression are extremely interesting. We get some of them on the Court of Appeals, and you get more of them on the Supreme Court. And so I look forward to that.
Thank you.
Mr. Spies.
Judge May, good to see you again, and always a pleasure to visit with you. You know, the concept of precedents and the degree to which appellate courts pay allegiance to precedents has taken a beating in recent days, and there's obviously room for growth in the law. And how do you see the role of the Supreme Court in growing the law?
Well, the court takes a relatively passive role by virtue of being a court, and the issues that come before us are the issues presented by the parties. And again, I'm being careful here about how to address this issue, but I think that what we have to do is continue to do what courts have done from the beginning, and that is address the issues presented by the parties. And if those issues are going to lead to growth because they are right under the law, then we're going to follow that path. Otherwise, I don't think that we are. Now, outside of our judicial decision-making process, there are many areas for growth in our judicial system. Not to kind of hijack the question into other areas, but when we think about, for example, in the administrative side, and what can we do in terms of continuing to encourage, I've talked to many of you about alternative courts, drug courts, mental health courts, veterans courts. What's our role in being able to continue to encourage that? I think that's an area where we can, as a Supreme Court, definitely encourage growth. And wherever I am in the judicial system, I'm going to continue to advocate for those things.
Ms. Eklund.
Judge, what is your first priority in being a fair arbitrator?
Well, I want to make sure I understand the dispute that's before me, make sure I'm not creating the issues, but that I really understand what the issue is in front of us. And then I want to find out what the law is, and I want to apply it to resolve that dispute.
Thank you.
Ms. Stanger?
Thank you. Good morning, Judge May.
Good morning.
Thank you for your application. We're delighted to have you join us. I want to touch on comments from another candidate. They use the word justice like 5 times in their statements. And clearly the judicial branch, right, is about justice for all and fairness. That's under attack, right, from politics and geography and implicit bias and all of these things that are hijacking transparency. Could you give us your thoughts about how to maintain, right, the legitimacy of the court throughout all of those challenges so that we are ensuring justice for all?
Well, my oath under Chapter 63 is to the best of my ability, provide justice under the law. And it's justice under the law that has to be kept in mind. If we are faithfully deciding cases according to the law, then we are providing the justice that we should. Now, how do we move additionally? What else can we do is maybe what you're asking. And there are many things we could talk about. And one of them is, for example, continuing our access to justice initiatives to try to make sure that unrepresented folks have ways to understand how the courts work and are able to represent themselves in cases. For example, when I was down at 5C, they started putting together videotapes to explain, okay, this is how you put together your dissolution decree, and this is how you come in for a modification, and those kind of things. And also through our judicial education, because the district judge or district associate judge has a tremendous role to play in assuring access to justice. And it's very simple things, like if we have 2 unrepresented folks come in, or even 1 unrepresented person versus a lawyer, that just taking that extra time to say, okay, we're going to have a hearing today, and first X is going to get to talk, and then you're going to get to talk, and then I'm going to make my ruling. So they know they're going to get to talk, and making sure that the unrepresented person feels heard. And then when you explain your decision, whatever it might be, whether it's for them or against them, trying to make sure that they understand why. Here's the statute, you don't qualify, or you do qualify, whichever it is, but trying to be transparent in that regard. It's small things, but I'm deeply concerned about the growth of unrepresented folks, because it is going up like this, and we have to make sure that they have what tools we can provide while remaining neutral, to continue to make sure that they not only receive justice under the law, but understand that they receive justice under the law.
Thank you.
Ms. Hanson, we have time for a short question.
No question.
Mr. Bevel?
Judge May, as a judge on the Court of Appeals, there are certain constraints that you have that would not be present, or would they be present on the Supreme Court?
Well, certainly I've written more than one opinion that says, well, it looks like the answer is X, but there's a Supreme Court case that says Y, so the answer is Y. And that is not a criticism of the Supreme Court. That is just how our process works. And even when you're on the Supreme Court, stare decisis still matters. Precedent still matters. It's not like you just wake up one day for no good reason and undo cases. But the Supreme Court, under the right circumstances, does have the opportunity to revisit its prior decisions. Court of Appeals doesn't.
Thank you.
Well, thank you, Judge May. Our time is up for today, and we appreciate your application and wish you the best.
Thank you so much. Thank you all.
The interview process is done for the morning, and we thank everybody for attending and for all the applications we received. The commission will now take a brief recess for lunch and then begin deliberations.